The last difference I can give is the law of limitations. Criminal cases have no limitation. There is, I think, a Luganda saying I used to hear where they say "Omsango te guvunda," while the civil cases are subject to limitation. For example, land cases are subject to limitation of 12 years. So you cannot bring a land suit, for example, from the year 12 years from ago is 2012. The case was a cause of action arose in August of 2012. It is now barred by the law of limitations. I should also state that what creates the offense or what creates the civil wrong is the facts of the case. So while I have highlighted the key differences between crimes and offenses, it is also important to note here, for purposes of our discussion here, that one act may establish both a civil wrong and a crime. What determines what will be described as an offense is the elements of the offense. If the elements are proved, then the offense can be both a Machumbi Gasasira versus Uganda, which is constitutional petition 17 of 2011, that criminal proceedings that both criminal proceedings and civil proceedings, which are based on the same facts, can be conducted concurrently. This, I think, is one of the issues that has precipitated the Honorable, the DPP, to ask us to discuss this particular topic. That one particular act can be both a civil wrong and a criminal act, and that proceedings can proceed in court both concurrently as a criminal prosecution and a civil case. The reason this is an application that is made very commonly in the criminal division, where individuals always try to stifle criminal cases because there is a civil case that is ongoing. Now that we have examined these broad descriptions, it can be concluded that offenses which are prohibited and criminalized by land law arising out of land matters are what we shall call land crimes. Then civil disputes and claims that infringe the civil law and arise out of individual or private interests in land. So what are the common offenses that we see when we are handling land matters? I am not going to go into the details, but we have offenses like removing of boundary marks. We have offenses like malicious damage to property. We have offenses like forcible detainer. We have offenses like forcible entry, setting fire to crops, forgeries of land documents. We have uttering of false documents. We have offenses that are created under the Registration of Titles Act, and offenses which are also created under the Land Act. I would like specifically to deal with the offense of criminal trespass, because it's the most common offense that is used in land matters. Criminal trespass is provided for under the Penal Code Act, and it is where a person enters upon property in possession of another with intent to commit an offense. It is also where a person unlawfully, oh, I thought you were coming for me. Okay. And a person who, having lawfully entered into or upon such property, remains there with intent to intimidate or annoy or commit an offense on the land, commits an offense of criminal trespass. Let us look at the elements of the offense of criminal trespass. Criminal trespass is established where a person enters on land and may or may not remain on the land. So there must be an entry onto the land. The land must be in the actual possession of another person. So possession is a key element when you're dealing with the offense of criminal trespass. And that possession must be at the time that the person is entering the land. So it is not anticipated possession. You can't say that I have filed for, I have started the process of taking the land under the RTA. I am likely to get this land at a future date. Therefore, anybody who is entering upon that land has committed the offense of criminal trespass. It must be at that actual point where you must have possession at that actual instance in time. The entry must be unlawful. This is important because we have the defense of claim of right, which we are going to look at shortly. Now, a person who has a claim of right over land cannot be found guilty of the offense of criminal trespass. It is a complete defense for an accused person to show that they have a bona fide belief that they are asserting a claim to property that belonged to them. I think this is very important because we have several cases where prosecutors and investigators are bringing cases of criminal trespass for prosecution, and yet the persons whom they are charging have a bona fide claim of right over the land. So it is important for us to make that definition and that distinction, because the fact that somebody has a claim of right over the land completely excludes criminal intention. It completely excludes, it removes the mens rea as far as the offense of criminal trespass is concerned. Therefore, if you have a bona fide claim of right, it is a complete defense to the offense of criminal trespass. On the other hand, trespass to land, the civil wrong, trespass to land, the civil wrong, occurs when a person makes an unauthorized entry upon land and thereby with the possession of the person who has custody of the land. Lawful custody of the land. Therefore, for criminal, the trespass of the trespass of the case of trespass to land is to the person who owns the land, not against the land, but the person who owns the land. That is, it is committed not against the land, but against the individual who has legal possession of the land. And when we talk of legal possession here, we include a person who has a certificate of title. Because under the Registration of Titles Act, as you remember, every certificate of title is conclusive evidence that the person who holds that certificate of title is the proprietor. So he does not have to be in actual physical possession of the land. He can also be in legal possession of the land. On the other hand, criminal trespass, you must be in actual physical possession of the land. Yes. Okay, I was getting carried away, so now let me see how to. Let's look at this question of criminalizing of land disputes. Criminalizing of land disputes, because that is one of the issues that I know we are facing here today as prosecutors. A number of our cases, which should otherwise be civil cases, are being criminalized. But in the case of Okello Orisatana versus Uganda, it was held that claim of ownership is a civil right that ought to be allowed to be proved in a civil court. You should allow me to prove the ownership of my land in a civil court, and it should never be criminalized so as to amount to persecution. Land matters have been criminalized, and courts of law are convicting persons who have a constitutional right to claim what truly belongs to them. This person is simply trying to assert his right of ownership, and you're criminalizing the case and prosecuting him. It was also held in the case of Sembadio Emmanuel that the only way to investigate and make appropriate orders in disputes regarding ownership lies through civil proceedings and not through criminal cases like criminal trespass. Of course, I am aware that because of the sheer pressure of land cases, for example, in the High Court, out of the 48,000 cases that we are handling, both at the circuit level and here in the divisions, 19,000 of those cases are land cases. So 40% of the cases in our system are land cases. As a result of that, there is a very big backlog in land matters. So our people think that by criminalizing land matters, they will have more expeditious justice, because it leads to the arrest of the individuals. Once individuals are arrested, then they are forced to negotiate. So I think that is one of the reasons why we have so many criminalized land matters. But I would urge you that if a matter is simply a person trying to assert their right of ownership, then really that should not be criminalized as a land matter. We should stop using cases of criminal trespass to prove ownership of land, because it is not possible to prove ownership using criminal trespass. The only way you can, the only thing that will end up there is for orders of imprisonment, but you will not vindicate the ownership rights of the individual who has brought the case of criminal trespass. I would therefore urge the office of the DPP, perhaps because of the sheer number of cases that are being criminalized, maybe you could come up with a checklist for determining what should be treated strictly as civil land matters and what matters should be handled as land crimes and which matters fall either way. The reason why I'm talking about the checklist is because I have seen that you have developed a checklist for private prosecutions. If you can have a checklist for private prosecutions, why can't you develop a checklist for cases which are being for you to check on what decision you should take as far as criminal land matters are concerned and civil actions are concerned? I think that would help all of us and reduce the backlog that we are having in the criminal system. I would also encourage you to, as prosecutors, as investigators, to divert land matters. Explore alternative methods of dispute resolution. So when litigants or when complainants come to you and you see that this is really a matter which can be handled as a civil matter, you can divert it to either, now the judiciary is developing alternative dispute resolution as a mechanism, as one of the mainstream mechanisms for resolving cases. So let us encourage purely civil matters to be handled as such. In conclusion, you can see that land-related disputes can be both civil and criminal in nature. Litigants and complainants may be motivated for various reasons to criminalize civil disputes. The reverse is also true. It therefore falls to the investigating officer and the prosecutor at the very outset to determine what the nature of the matter is. The focus should be on handling purely criminal matters as efficiently as we possibly can with the scarce resources that we have. That will help us reduce the backlog. I thank you very much for listening to me.
Let's put our hands together again for Justice Elubu. Thank you so much, Justice Elubu, because he has dissected for us criminalizing land cases. I think that's a problem that we have. We are being used to actually encourage wrong individuals to grab land because they come and report criminal trespass, and quickly we sanction the charges, the police go, throw someone in the cells, 2 days, the land is transferred. So please, let's look at that. We have also taken note of the checklist. Actually, as we speak now, we have given the lands department an assignment to actually do a research for us. First, just to give us what is a land crime so that we can define that. That will help us to come up with a checklist. I have also noted diversion. If we have to really handle all the land cases, we shall not manage. So I think diversion is a good thing and we should explore that. Thank you so much, Justice Elubu. Now we are going to the next segment. I think we shall reserve the questions after because we have all the presenters for the next session. The next session is going to, people who are lawyers will understand this. When we were in law school, we still had, we were still 60 in number, always. And then we went to LDC, we had only 4 law firms, but there was one notorious law firm called Farm D. It had all the elements who think outside the box. You remember those moots? And it was a murder case. And we were the ones who were, I think, for the prosecution. And we started the moot. We were there, I think Justice Madrama was the judge. And then the farm, the defendants, said, we have a PO to raise. And they said, what? They said, if this was a murder case, we have had the prosecution saying so-and-so was murdered. But the person they say is dead is right here in court. And one of them stood up. And we were thrown off balance. And that was none other than the Honorable Attorney General himself. So we are having him as the first presenter today. I always thinking outside the box. The Honorable Attorney General, you're most welcome to come and take us through this very important topic, the law that is biting the prosecutors and the investigators and is almost stopping us from doing our work. But it is very important that we are told how to toe the line. So the Honorable Attorney General, please come and take us through.
Thank you very much. By the way, that is the brief I got. I'm not the one who was trying to conjure up evidence. That is what the client told me, that the person they are accusing of death is right here. The Honorable Ministers present, Honorable Justices, members of the Justice, Law and Order sector present, all of you in your various capacities, thank you very much for coming. I was given a topic to discuss, which is actually a very, very problematic topic. It borders on management of human rights, while also dealing with the question of management of people's rights. So the issue we are dealing with is the Human Rights Enforcement Act of 2019. And the questions I was given was, given the Human Rights Enforcement Act's emphasis on nullifying criminal proceedings due to rights violation, how do we ensure that the applications lodged on allegations of human rights violation do not compromise the integrity and pursuit of justice? The next question, I was given 3 questions and I'm going to try and handle them together. The next question was, how was the Human Rights Enforcement Act's implementation affected the overall efficiency and effectiveness of the Uganda criminal justice system? And are there unintended consequences, or I may add, are there intended consequences, or areas where reform might be necessary to ensure that Human Rights and Enforcement Act is serving its intended purpose while maintaining and fostering a fair and efficient criminal justice system, practice, or bringing perpetrators of crime to justice? Ladies and gentlemen, you have spent a couple of days discussing criminal justice. And what this law basically says is that in Uganda, we must enforce human rights. We all agree. And it says that if you violate human rights, you are liable. I think we all agree. Then it says that if an alleged criminal has his rights violated, then he should not be tried. That's the summary of this case, of this law. So it says that in specific terms that if it appears to a judge or a magistrate presiding over a trial, it is brought to the attention of a competent court, or the court makes a finding that any accused person's non-derogable rights are right to a fair hearing, the right to be protected against torture, the right to be against slavery. Those are the non-derogable rights. Then upon the judge or the magistrate presiding over the trial shall declare a nullity and acquit the accused. That's section 11. Ladies and gentlemen, I hold the view that that provision is unconstitutional. That's my view. And the reason I hold the view, that view, is because one, the Constitution demands of the state that anyone who commits an offense must be prosecuted, must be brought to court. Now, let me give an example. A person murders someone in the village, and in the process of being arrested, he complains that his human rights have been violated. He goes to court and tells the judge that my human rights were violated. I was actually beaten, and this is what happened, so I was tortured. So the court indeed finds that this person was tortured. Let's assume that the court actually finds this person was tortured. Then the court says, you are acquitted of murder because you were tortured. That's unconstitutional, absolutely unconstitutional. Because acquittal must arise from trial. Acquittal must arise from a judge looking at the facts of the case and finding that you have not proved that case beyond reasonable doubt. Now, to find that an offense was committed against the accused after the accused committed an offense and therefore they are acquitted, I think that is a violation of the Constitution. But again, doesn't the Constitution protect the accused as well as the rights of the victim? So if you acquitted the accused, what do you do with the rights of the victim? What do you do about the rights of the complainant? So there is a need for the courts to balance the pursuit of justice from both sides. You balance them by ensuring that the rights of the victim and the right of the accused have both been taken care of. So that brings me to the fact that the courts must exercise judicial discretion. Of course, I don't agree that a person should be put on trial when he's hurting from wounds and etc. But like you said, Honorable Justice Elubu, omusango teguvunda. So you go, heal, then stand trial. Yeah, you are tortured, go, get treated, then answer the charges against you. But also, the person who committed the offense that is alleged also has a right to be tried, give his defense in a criminal prosecution, and then find them guilty or otherwise. So we are saying, try the person who violated the right, also try the person who committed the offense. It is in order to ensure that these violations do not compromise the justice of the victim, there must be transparency and due process. Now, colleagues who have come across this law, what happens is that you go to court, you have a person under charge, then the court is told, my rights were violated. Then the court says, let's stop the prosecution of this charge. Then the court, sitting as a civil court, the court sitting as a civil court stops a criminal prosecution. That line should never be crossed. law requires conviction beyond reasonable doubt. Civil requires proof on the balance of probabilities. How can a civil court make a finding that there was torture and on the basis of that call for an acquittal? It's a total contradiction, and this we must deal with. I also agree that arrest should be based on reasonable cause, reasonable suspicion. But let's not live in a utopian world. Let's not live in a utopian world. I was reading yesterday, and one of my colleagues had an argument that if the police enters a place with an arrest warrant to arrest me, and he finds in my house a cache of guns, but it doesn't have an arrest warrant, what do they do? So some very good genius told me that the police should go back, get a search warrant, then come back and get the guns. This is utopian. It's a joke. You have found the guns. And I wrote back to the IGP and said, no, sir, please, when you go to arrest someone, and you find evidence of a commission of another offense, get those things also. Tell us, I need a search warrant so I can go back, and while the criminals are waiting for you, so that you come back with an arrest warrant. So we need to read the laws within the realm of reality. These laws are not there. They are there to protect both the victim and also the accused. But you must remember that criminal law is public law. And like Justice Elubu said, you must distinguish between public law and individual law. So, arrest based on reasonable suspicion. But who determines that reasonable suspicion? Is it the public? Is it the arresting officer? Is it the judge? At the time you get to the court, it must be the arresting officer. The arresting officer is the one who must be reasonably convinced that there is a crime that is about to be committed or that has been committed, and then you arrest. But you can actually arrest before you complete the investigation. If in your view, the arrest will stop the commission of a further crime. So all these things must be done in the realm of that investigation, because when the police is dealing with criminals, it's not dealing with very reasonable people, but by no standards are they to be considered stupid. They may be unreasonable, but they are very intelligent people. It actually takes more work to commit a crime than to avoid committing the crime. So, the Constitution in Article 23(4) says that the police should present a person before the court within 48 hours. We have read it to mean that I must present this person and charge them within 48 hours. No, that's not the view I hold. And I think it is about time we go to the courts to tell us what it means. I have arrested someone on the reasonable suspicion that he is going or has committed an offense. I have the murder weapon, like Justice Abodo was saying. I haven't found the dead body, but I have found blood everywhere. I have checked DNA is there, but I'm trying to figure out whose DNA it is. DNA doesn't happen in 6 hours. DNA happens in more than 48 hours. It could take even longer. Now, we have our capacity here, but before we didn't even have the capacity. But this Constitution has been here since 1995. So the rule in 23(4) is saying, bring the person before the court within 48 hours. You don't have to charge. You go to the judge, you say, I have person A in my custody. I believe he has committed an offense. I have this much evidence, but I have 3 or 4 areas that I must check. I am asking you, my Lord, don't release this person from our custody. Allow us to detain them longer. The purpose of that law was for you to account to the court for purposes of habeas corpus, to make sure that once you present him before the court, then that person is under the custody of the court. In fact, the court may not even agree with you. The court may say, from what I am seeing, there is no reasonable suspicion, you must release them. That is up to the court. But we must be careful to read these things to say, 48 hours, they've reported an offense, I've arrested the person, I must do charge sheets. Okay, we are very efficient as government, but I don't think the law expected us to think, investigate, write, and finish. The ideal situation is the offense is reported, you investigate it, then you arrest. What if it is a terror threat? What if the police has reasonable suspicion this person is about to blow up police headquarters? But if he arrests him in 48 hours, I'm not ready to charge him because others are still at large. So what he does, because the Constitution says you must charge, if you read it that way, the police must release. So if the police releases and it blows up the building, we will hold you police accountable. Because you had him, you could have brought him to the court and then tell the court what it is that makes you believe. This Constitution was written by people who are clear in their mind. If they wanted to say, be presented before the court and charged, they could have said so. But they said, be presented before the court. But that is a matter we are going to deal with, because I am sure it is going to become an issue, and we shall come to the court and discuss with the court why we think. And in other jurisdictions, it has even been made clearer. They have allowed you, they've written laws and said, bring them, and then you can have the detention extended. Now, in enforcement of, the Human Rights Enforcement Act, that's one of the areas we have found. 48 hours, you have violated my rights. First of all, detention more than 48 hours is not one of the non-derogable rights. Let's be clear. You cannot go to the court and say that my non-derogable right was violated because I was detained for more than 48 hours. No. But we've seen the courts saying this person was detained for more than 48 hours, and therefore the trial is a nullity. Medical examination. A person is said to have been tortured. Police, you must now up your game, because those of us who defend these cases need to be armed with sufficient material to defend the cases. I do not think you will find the conversation with me very pleasurable if they show me a picture of a person in a cast with a broken leg, and then you're telling me he wasn't tortured, he came that way. That when I arrested him, his leg was broken, he had 10 wounds, but you're telling me after he has complained to the court. Why don't you do the examination when you are arresting this person? Why don't you do the examination, have a good record of under what? It is not likely that a notorious gangster is going to come to police without a wound. It's not likely, because if this person is notorious and has been carrying out these notorious raids, he's jumping over fences, going through barbed wire, breaking all into cars, he's going to have some wounds. But if you wait for him to complain, then you bring us a problem, and you bring the courts a problem. So carry out your medical examination of this person so that it is clear how this person was brought to your custody. And it's the same thing with prisons. When they bring the person there, be clear as to how this person, in what state was this person brought to you. Then we can be able to go to the court and say, no, on this date, this is what happened. And that also deals with video recording and audio recording of interrogation. It's very important that we get to that point, because as a country, as a government, we will not tolerate the violation of human rights. We will not tolerate torture. We will not tolerate cruel. Actually, there are few of our friends in our midst in the past who I refuse to defend, because they brought the matter. I looked at the facts were not right. So they said, no, but I was acting in the course of my employment. I said, this government told to go and beat that person. It can't be in the course of your employment. You beat this person on your own. So you go and defend yourself. But for those who do so and happen to act in the course of their employment and they arrest someone, no one is being arrested nicely. No one is going to just say, here I am. They will always fight. So if you come to me and say, in the process, I asked this person that I'm arresting them, they insisted and they fought back, and in the process, I seem to have exerted some bit of pressure on him. I say, can you explain to me how you exerted this pressure? Say, I swung left, swung right, and I had to detain this person forcefully. Then I may come in and say, no, this is not torture, this is not degrading. But the important thing here is that you need, as police, as the law enforcement agencies, you need to get out of these processes as clean and as neat as possible by taking a good record of what transpired. So, Section 8.1 of the Human Rights Enforcement Act talks about staying of proceedings. My lords who are here and members of the jealous sector here, I find this a bit problematic, because now, by this law, we have prioritized civil proceedings over criminal proceedings. Now, that I don't think is a desirable consequence of this law. Remember, one of the tenets of the Constitution requires you to conduct a speedy trial. But secondly, a delay in criminal proceedings also affects the ability to prosecute the case. I had a lecturer whom I will not name in law school who told us that the easiest way to defend a criminal case is delay it. The easiest way to defend a criminal case is delay it. Why? Witnesses die because they are human beings. Witnesses forget. Evidence gets, because some of this material paper gets degraded. If you have a piece of cloth with a lot of blood and you keep it for a couple of years, by the time you present it to the court, it will be in shreds because it's naturally happening. So the courts need to defend themselves, to defend the Constitution by saying, if we insist on delaying criminal prosecution, we are going to insist on releasing criminals. So this staying of criminal prosecution because of an allegation of violation of human rights, in my view, has that unintended consequence. But also it increases the backlog, because remember, the judge who came to hear a criminal trial now has to hear many applications. Actually, in our space there, we spend a lot of time now. I think now it has become the norm. I hardly find any criminal case where we do not have to defend a human rights enforcement case. Every trial comes with a human rights enforcement issue. So we need to be careful not to render the DPP redundant and the Uganda Human Rights Commission, because what happens now is that the DPP puts the case on the side does other matters, then the Attorney General comes in. Go to the High Court, go to the Court of Appeal. The Court of Appeal says after a couple of years that go back to trial. Then the DPP, who had prepared the case, the officer who investigated the case has been transferred to Ntungamo. Now we have to start looking for the officer to bring him back. It's costly, it's very problematic. So that is the second unintended consequence. The third one is the disenfranchising of the victim. I've already spoken of it. My relative has been killed. I did not participate even in violating this person's rights. Now you make it my problem. The person who killed my brother is now out. So what is going to happen? You're going to encourage mob justice. Because the person, the victim, feels violated because they allegedly violated this person's rights at the time of arrest. Then another provision which I have a very serious problem with, and it is double-edged, is the personal liability of the law enforcement officer. And the provision reads that the provision does not have a provision, does not have the part which says in the course of his employment. Now, if we send out police officers to carry out their duties, and they carry out their duties in the course of their employment, and then you come back and say they're personally liable for these acts. So where is the state that sent them? Where is the state that sent them? Now, we are struggling all the time with these cases where we have to go to the court and apply for substitution. You've brought this officer. What this officer did, in our view, was done in the course of his employment. So as the state, we accept that we will be vicariously liable if this person, if what he did was wrong. But the personal liability should be for the personal acts of the police officer. For example, if the person is in detention already, and the police officer beats this person, that's different. That cannot be in the course of his employment. What was he doing? But a police officer is carrying out an arrest, and in the process of the arrest, they enter into a fight because he's carrying out an arrest. Then you say the police officer is personally liable. So we need to clarify that in the course of his employment. And we have many decided cases on that, but it's becoming a thing. And my worry with that is that it now says, the police officer says, why should I even bother getting involved in this? So what are we doing? We're going to encourage crime. Because now the police officer is saying, well, I'll be held personally liable. So he says, hello, Sumama. The man runs, says, if I chase this man, I'll be personally liable. Because if he chases him and he falls, I'll be personally liable. Come back, come back. We can't operate in that kind of setting. The police officer is entitled to exercise reasonable force. The question that every police officer must always answer when you come to me is whether your force was reasonable. And that you must be very careful, because therein lies the line between right and wrong. But do not stop doing your work because they will hold you personally liable. So my view of those 4 unintended consequences is that just those 4 are going to clamor down on the criminal justice process. They are going to weigh heavily on the process of prosecution of criminal justice. And the members of the bench who are here really need to think about these things very, very seriously. And someone argued that they said shall, but the courts have also said shall should not ever interfere with judicial discretion. I have in many cases where the court has said shall cannot take away the judicial discretion given to the court in the Constitution. So the Human Rights Enforcement Act cannot be used as a shield to say every time the matter comes, I stay it. And once I stay it, we don't proceed. No. You need to exercise that judicial discretion to protect definitely the rights of the victim, the rights of the accused, and also to hold the government and the state accountable for their actions. So this Human Rights Enforcement Act, I think, unless because it was, I think we were overzealous in where we were going with it, it serves a vital purpose because it helps us to ensure that we do not violate the human rights. But I think it has not served its intended purpose. So I am still struggling, and since we have many lawyers here, please go and think about it. And I think since we are in government and the minister colleagues are here, when I bring a law to cabinet, you will support me. Everyone can bring an action to say that a matter is unconstitutional, and they can bring it against the Attorney General. What does the Attorney General do when he thinks the matter is unconstitutional, and yet we have not found political consensus on it? Think about it. In other jurisdictions, attorneys general have been allowed to state the case to the court. To state the case to the court for the court to guide, where I hold the view that is unconstitutional, but we have not had political consensus that is unconstitutional, yet indeed we need to find a solution to it. So in view of those shortcomings, I think we need to amend this law. Section 7(1) and 2, as I've stated, needs to be amended to make sure that we also take care of the rights of the victim. Section 8(2) needs to be amended to take into account the nature and seriousness of the violation alleged, and also the facts before the court. I think here, even without the amendment, the court needs to be able to use its judicial discretion. So, Section 15 needs to be amended because I don't even know why it needs to be amended. A person who thinks they have been unlawfully detained can actually ask the court to cause the person to be released. So, ladies and gentlemen, colleagues, I think while the law may have been well-intended, I think the practical consequences of its implementation have hit the point at which we are now about to fail to prosecute criminal cases. And it is about time that we seriously rethought this process so as to avoid the unintended consequences and the effect on the judicial service, the criminal justice system, but more importantly, to avoid sending a message to the people that you can get away with commission of a criminal offense because your rights have been violated. I thank you very much.
Another round of applause for the Honorable, the Attorney General. He always thinks outside the box. I'm not going to dilute his presentation. It is very clear. Yeah, it is very hot. It is very clear. The takeaways are very clear. And I think it is just that we need to do something for the rights of the victims as well. Our next presenter is none other than my sister, Mariam Fauzat Wangadia, the chairperson of the Uganda Human Rights Commission. You're most welcome.
seems we are terminating the presentation because he has approached it. Yeah. That's what I've been given as a briefing. According to what they've told me, is we now just wait for him. Use this one.
of a suspect on the basis of a finding of infringement of the suspect's non-derogable rights. This reasoning totally defeats the principle of criminal responsibility. Because of the misdeeds of a law enforcement officer, the criminal actions of an accused person are simply washed away with no regard whatsoever to the victims behind the suspect. The loss suffered by the ones I refer to as the actual victims, and in total disregard of the fact that had it not been for the actions of the accused person, he or she would not have come into contact